Good afternoon. I'm Elise Jamie, and I would firstly like to thank you for attending this seminar on transfer risk assessments. Emma and I are very grateful for your interest in this topic and really appreciate you taking the time to listen to us today. Next slide, please. On the slide before you is a list of the topics that we will cover. As you can see, we will begin by explaining the background to TRAs. We will then guide you through the development of the ICO's thinking in this area. And finally, we will provide you with a preview of the ICO's new TRA tool and guidance. Next slide, please. Now, the ICO's work in this area was triggered by the CJEU decision in Schrems II on the 16th of July 2020. And of course, the impact of that decision is set amongst the backdrop of the UK's departure from the European Union. On the 10th of November 2020, the EDPB published two sets of recommendations. Recommendations on measures that supplement transfer tools and also recommendations for the European essential guarantees for surveillance measures. On the 4th of June 2021, the Commission published new EU SCCs. These are not recognised in the UK because they were adopted after the UK had left the European Union. On the 11th of August 2021, the ICO launched its consultation in relation to its international transfers guidance, the IDTA, the addendum to the EU SCCs, and the ICO transfer risk assessment. In September 2021, we conducted a series of workshops with stakeholders on these documents, and then the consultation period closed on the 11th of October 2021. On the 2nd of February 2022, the IDTA and the EU addendum were laid before Parliament, and they came into force on the 21st of March 2022. Next slide, please. So the Schrems II decision was a key ruling by the CJEU in July 2020. The court invalidated the EU-US Privacy Shield decision, finding that US law did not ensure an adequate level of protection required under Article 45 GDPR. The court also held that Article 46 transfer tools must provide a level of protection essentially equivalent to that guaranteed within the EU by the GDPR, read in light of the Charter of Fundamental Rights of the European Union. An assessment of the level of protection provided by an Article 46 transfer tool in the destination country must be performed before making a restricted transfer of personal data. Now, the decision in Schrems II continues to apply to the UK following Brexit, and the level of protection guaranteed by the UK GDPR is to be read in light of the European Convention of Human Rights as incorporated into UK law under the Human Rights Act 1998. Next slide, please. Now, the EDPB has interpreted the decision in Schrems II as meaning that a comparative assessment is required between the legal framework of the EU and the legal framework of the destination country. The EDPB recommendations on supplementary measures asks exporters to consider whether there is anything in the law or practice of the third country that may impinge on the effectiveness of the appropriate safeguards of the Article 46 transfer tool. And it asks exporters to determine how the domestic legal order of the country to which the data is transferred applies to the transfers. On the 25th of May 2022, the European Commission confirmed the EDPB interpretation in its questions and answers on the new EU SCCs. The guidance states that clause 14 of the new SECs should not be read in isolation, but should be used together with the EDPB recommendations on supplementary measures. Next slide, please. Now, in the consultation on international transfers, the ICO presented a risk-based assessment, which would allow international transfers of personal data where there was a low risk of harm to data subjects. We identified two broad types of risk. Firstly, the risk that the IDTA would not be enforceable in the destination country. And secondly, the risk of third-party access in the destination country. We then provided a number of tables with various indicators to help the UK exporter in this assessment. The key question was whether there was a risk of third-party access or government surveillance without sufficiently similar safeguards to those in the UK. Next slide, please. In respect to feedback from the consultation, respondents told us that the requirement for businesses to assess third country legal frameworks is prohibitive and burdensome, especially for SMEs. We were told that there was a need for country-specific guidance from either the ICO or the government. And we were also told that businesses need to know who is responsible for completing the TRA. Is it the responsibility of the exporter or the importer? And finally, businesses asked for confirmation that they can follow the EDPB recommendations if they would like to. I will now hand over to Emma Bates, who will talk you through the changes that we have made to the TRA in response to the consultation feedback we received.
Thanks, Elise. Next slide, please. So before I come on to our transfer risk assessment guidance, it's worth mentioning that following the consultation, we are updating our guidance on international transfers. You'll recall that we refer to international personal data transfers as restricted transfers in our guidance. Some of these we made when the IDTA and addendum were published back in February, and some will be coming very soon. The final version of our updated guidance is on my desk, and I just need to check it all off. First, we confirm that it's either the controller or the processor which is responsible for compliance with Chapter 5, the transfer rules, not both. And it will be the organisation that has instigated the transfer which is responsible. For a processor, it's usually going to be when it's to its sub-processor. Second, the restricted transfer will follow the contractual protections rather than the flow of data. This ensures the protections are in place, and it should be clear which organisation is responsible for the transfer and the transfer risk assessment. And third, there is no restricted transfer, and so you don't need to do a transfer risk assessment when a processor is returning its data back to its non-UK controller. So next slide, please. So following the consultation, although people were broadly positive about the approach that we'd taken in the consultation, the loudest message was how difficult and costly it was to carry out a TRA, and whether it was even possible to assess the laws and practices of a third country in this way, in particular public authority surveillance. Can a UK exporter ever really know how an overseas government accesses and reviews data in its country? So given that, we decided to go back to the beginning and look at the UK GDPR and the Schrems II judgment with fresh eyes. And we came to a few different conclusions, as you will see. So first of all, it must be interpreted in the light of the European Convention of Human Rights and the rule of law. So the requirement must be achievable and proportionate. And we feel quite confident that both the CJEU and a UK court would agree with us on that. European and UK public law is flexible, and the intention of the CJEU judges in Schrems II would not be to expect the impossible or even the extremely difficult and costly. The next conclusion we came to is that the risk assessment needs to focus on real and identifiable risks to data subject once or if data leaves the protection of the transfer tool. And we think this needs to involve a consideration of privacy and other human rights risks. And bringing those two factors together does seem sensible. There are many public resources on human rights in different countries, which we think will be more straightforward to review and consider. Can we go on to the next slide, please? Because of the level of interest in our guidance on transfer risk assessment, we've been continually being asked when's it coming out. So we thought it would be really helpful today to give you this preview, but there's a big caveat to say it's not final yet, so please don't place reliance on it as yet in our guidance. We're still trying to work out, the precise wording and the precise order and all those things, but this is going to give you a really strong flavour of the direction of travel of our TRA guidance. Our current view is that there are two options and both are valid. Option one is following the EDPB and Commission guidance, where you compare the laws and practices of the destination country with the UK. This means that you can continue with your current approach to transfer risk assessments, and for multinational businesses, you can use one approach across your European businesses. But we do think there is a second option, where you compare the position of the data subjects when the data is in the UK and once it's been transferred. In particular, you'll consider if their risk to privacy and other human rights has been significantly increased by the transfer. Can we go on to the next slide, please? So we've worked this second option up into our TRA tool, which currently, again, it's in draft, has 7 steps. So step 1 is a reminder that you can't forget the rest of UK GDPR, so it nudges you to check on some of the key requirements. Step 2 is where you will set out the specific circumstances of your transfer. In particular, you'll be scoping out which categories of data are going, where is it going to, key details of the third country importer, and so on and so on. Then at step 3, we would ask you to assign a risk level to the data you're transferring, and we will give you guidance on how to do this. This is then needed for step 4. So based on the risk level you've assigned to your data, you can then decide what is a reasonable and proportionate investigation. And based on that investigation, you will then go on to answer questions 5, 6, and maybe 7. So in our TRA tool, we will be giving you guidance of the kind of resources you need to look at the different risk levels. So, for example, for a lower risk transfer, you can look at the Foreign, Commonwealth and Development Office's Human Rights and Democracy reports, and the Department for International Trade's Doing Business guides, and maybe some human rights reports from reputable charities. For riskier transfers, you may still need to carry out a detailed investigation of local laws and practices, but focusing on the risk to privacy and other human rights. Then, once you've carried out your investigation, you can then move on to step 5 and answer the next question. So thinking about your data subjects and the circumstances of the transfer, is there more than a low risk of a breach of privacy and other human rights in the third country? And if there is this risk significantly increased by your transfer? Is your transfer making this risk worse? So, for example, if you're sending data about a person's LGBTQ status to a country where there is a risk to human rights linked to that status, does your transfer increase those risks for those data subjects? Another example, if you're sending, say, HR data to a country with the death penalty for serious crimes, unless there are particular circumstances, you might conclude that the transfer isn't going to increase the risk of that particular human rights breach for your data subjects. At the end of this step, you'll be able to make a note if there's any specific personal data where you think there is a significant risk to the data subject's privacy and other human rights, and you're going to need that for step 7. Next slide, please. So now we move on to step 6, where we're thinking about the enforceability of the transfer tool, both for you and the data subjects. It's actually quite tricky to find the right wording here because it's always, a low likelihood that you're going to need to enforce a contract in court, but the whole point of a transfer tool is that it provides effective and enforceable rights. So First, you need to ask yourself, if the worst happens, are you satisfied that you and a data subject would be able to enforce the transfer tool in the UK? In other words, would the importer accept a UK judgment or an arbitration award? And again, we're going to provide guidance to help you answer that question. For an importer with no UK base, it's often a commercial question. Is there enough of a commercial impetus for the importer to accept the UK judgment or award without you having to go to their home country to try and enforce it in the local courts? If you think you or a data subject might need to enforce outside the UK, then again, looking back at your investigation, do you have any concerns that you will encounter significant difficulties in this? So in the reports, you might be looking for concerns about respect for the rule of law, the independence of the judiciary, and how quickly the courts process cases. And then again, at the end of that question, you might identify certain categories of data where you do have concerns. And you then take that data from question 5 and question 6 and move on to step 7. At step 7, you're considering if an exception, one of the Article 49 exceptions in the UK GDPR, if that could apply to the data. And you can focus just on the data where you do think there are significant risks and just focus on the risks you have identified. And we're going to help produce a decision tree to take you through the exceptions and help you with that decision making. Next slide, please. Now, this might, at first hearing, this might all seem quite complicated. There are 7 steps, it's quite long. How are you going to do it? But there are just 3 key killer questions that you're going to need to think about. First, your assessment of the level of risk of the data being transferred. And we're working on giving quite detailed guidance about all different categories of data and factors that might increase or decrease the risk. Second, whether your transfer is significantly increasing the risk of a privacy or human rights breach. And our thinking is that if you've done your investigation, you should be able to identify relevant human rights risks from those kind of reports. And then third, if the worst happens, will you and the data subject be able to enforce that transfer tool? Next slide, please. So we're also producing something we're calling a TRA record, which is hopefully going to be a user-friendly and comprehensive document with lots of tables and tick boxes. And the aim is that it's going to make it as easy as possible for an SME or a DPO to work their way through the transfer risk assessment and set out all their findings, so they've also got a useful record for their accountability obligations. But just to say, it isn't compulsory to use the TRA record. It's there if it's helpful to you. Next slide, please. So where are we up to and what are our next steps? So shortly, we would like to publish the summary of the consultation responses and, as I mentioned earlier, our update to international transfers guidance. Then again, hopefully over the summer, we should be publishing our transfer risk assessment guidance tool and record. And if it's not over the summer, it will be shortly afterwards. Then when we get to the autumn, we'll go back to the IDTA and the addendum, and we'll look at providing some simple guidance as to how to use it and some clause by clause guidance on those contracts. And at that point, we'll then have another think about what other tools could be helpful to you. Do we need to produce an online contract generator, or are there others out there in the market? Could we provide examples of TRA records? And if there are things that you think might be useful, then please do give us feedback on that. So I think we're now moving on to the next slide, which is questions. But before we go to questions, I just wanted to say, so if you've just heard all this for the first time, if you do want to give us instant feedback, then please do use the feedback forms that come along with these sessions, and we will have a look at them and see what your thoughts are. And then I'm going to have to go and have a look at the chat side now to have a look at the questions, if that's all right. I'll just try and work my way through. So one of the questions is, if you've already produced your transfer risk assessment, do you have to use the new tool? No, you don't. If you followed one of the two options that we're suggesting, which you probably will have followed the EDPB guidance, then that's absolutely fine. If you followed the version that was in our consultation document, then that will be fine as well, because in our guidance we'll be saying, we're still comfortable that, what transfer risk assessments which find there's only a low risk of harm are, the data is able to flow on that basis. So no, you shouldn't have to go back over your transfer risk assessments. We've got a question if there's a simpler version of the IDTA. Not at the moment, but we will have a look at that in the autumn to see what we can do to help people entering into the IDTA and the addendum. So we'll give us some time and we'll come to that soon. I'm just having a look at the question, sorry. We've got some, I'm just skipping through because we've got some questions on the IDTA rather than on the transfer risk assessment. So let me just see if there's questions on that. So there's a question, can the IDTA cover transfers across global organisations? Does a risk assessment need to be carried out in each country where the entity is operating? I think, you can group transfers together and you can group them in your IDTA if that helped, if you were doing sort of a multi-party IDTA for a group company. But for the transfer risk assessment, yes, you can group transfers together, but there will have to be some kind of separate assessment on a country by country basis, because you're going to be looking at the privacy and human rights risks and the enforcement risks for particular countries. So I think you're still going to have to do it country by country, but you might group them together. I'm just looking for the next question. So we've got a question about on the clarification that it is the instigator of the transfer which needs to do the TRA, using a SaaS providers as an example, which provide a standard service to a customers as a processor, which involves restricted transfers. So yes, it probably, I mean, I wouldn't be able to say with certainty unless you look at all the circumstances, but I would expect in that situation, it would be the SaaS provider that would be responsible for the transfer risk assessments and for the restricted transfers that it's instigating, for example, to all of its sub-processors and sub-processors. So there's a question about, will we be providing country risk assessment? So there's no plans to do that at the moment. We will keep coming back to this and looking at what's appropriate. Once we've got our transfer risk assessment tool and guidance, we will, ask ourselves, what more can we do? What more can we do to help people? And is it possible? Is it appropriate for us to provide that kind of information? And is it helpful? So we hear that message and we're still keeping it under review as we work through this process. There's a question which is, how does this approach alleviate the burden on organisations to assess the laws and practices of the third countries? Well, it should help, because you're now not having to, ask questions about the whole range of laws and practices in a third country. You should be able to focus just on human rights risks, and there are lots of public resources which set out human rights risks. There might be at the top end of the spectrum of risk where it's very high risk data. You might also need to look at some of the laws and practices, although to be honest, we're still sort of figuring out the different risk levels and what's reasonable and proportionate. But this should be a much more straightforward assessment and much easier for an individual to be able to look at the public resources available to them and make the assessment themselves. Somebody's also asked, what exactly do you mean by position? I think what we mean by position is then explained in the questions which follow. I know it's one of those words which is, what does that mean? But we explain what that means by the questions that then follow. There's another, so I have to read the questions and then work out if it's something I can answer at the same time, and they're all quite long. I've done that one. Yes, the guidance of the tool should be published before the September deadline. Unless something happens in the meantime that is unexpected, yes, it should be coming out before then. So we've got a question about the responsibility between the controllers and the processors about particular countries. If a controller and whether, so I'll just read it out, sorry. In the case of international companies, there is a risk with your approach on the data controller and data processor responsible for the transfer risk assessment. A data processor could decide a country is safe for transfer for a specific project when the data controller has decided to the contrary. This ought to be the data controller's responsibility to avoid conflict and avoid unnecessary cost of the data processor repeating the transfer risk assessment the data controller has concluded. So our interpretation, our view of the Chapter 5 rules is that it can only be one, it can't be both that's responsible for a transfer risk assessment and for the restricted transfer. And there have to be, because Chapter 5 talks about controllers and processors, there have to be occasions when it is the processor's responsibility to comply with those Chapter 5 rules. So starting from that position, in practice, if it is the processor that's responsible for the restricted transfer and for the transfer risk assessment, it is still the gift of the controller to, as controller to say, we'd rather you didn't use that particular country. They will have the opportunity to see to look at processes that have been used or to put it into the contract that there are particular countries that they don't want to use. So it's meant to be it should be more cost efficient to have it either the controller or the processor who's responsible, but it has to be one or the other. And if the controller's already done a transfer risk assessment, then it's open to it to share that with the processor if it so wants. Right, I'm going on to the next question. How can the ICO support a controller or processor who carry out frequent transfers to third countries? The detailed investigations are potentially burdensome for such frequent transfers. So I think under our guidance, you will be able to sort of bunch transfers together, and you'll be able to do a transfer risk assessment, which will cover multiple transfers, provided that the specific circumstances are the same or very similar. And then, if you have a standard for a particular transfer, you can always reuse that for another one and then just change certain details. So it should be possible to sort of group your restricted transfers together, but probably on a country by country basis, because you do need to do that specific country assessment. I'm just scrolling down to see what other questions we've got. So we've got a question, is it realistic to expect small charities, SMEs and startups to go through all this because they want to use Office 365 or MailChimp, for example? So the first point I'd make on that is to look at whether it is you, the small business, that is actually making the restricted transfer, because if you are contracting with a UK business, it won't be you making the restricted transfer, but it might be the UK business that is actually responsible for that restricted transfer to their sub-processors. And then we are taking this into consideration, and we will try and make the tool as user-friendly as possible when it comes through, and to make it straightforward as we can, even for an SME or a small charity. I'm sorry, I'm still going through all the questions. I'm just trying to see if there's any that there's a lot. Let's have a look. So there's a question which is there any ambition within the ICO to collate outcomes of transfer risk assessments and collate key elements of the proposed transfers? We are thinking whether we can provide example transfer risk assessments, which I think is probably answering that question, which might well help for specific types of transfer. There's a question whether a DPIA has been, if that's been undertaken for a data system where the transfer of data is overseas, is this adequate? They're two different requirements. You could put them together if you wanted to into your DPIA could be extended to cover the things you need to consider in a transfer risk assessment, but they're asking, I think they would be looking at slightly different things. So it would be up to you how you wanted to conduct your DPIA. There are some questions that I'm not able to answer, so I'm just skipping over those. Yeah, we've had another question about, are we looking at sample risk assessments, about sharing samples and best practice? Yes, we are looking at that, and we would like to do that. We've got a question about UK processors returning data to their controllers outside the EU. Whether you still need an IDTA. No, you don't need an IDTA. It's not a restricted transfer, so it wouldn't be caught by the rules in Chapter 5 of the UK GDPR. We have a question whether EEA regulators support this approach. Well, we haven't shared this with them yet. We are hoping to do so, and you know, we've had some side conversations with them, but I think we haven't been in a position yet to share our thinking on this. So the answer is we don't know, but we would be hopeful that, you know, if we've got, you know, it should be clear what our rationale is behind it, and hopefully that will be acknowledged by our colleagues across Europe. Will TRA guidance include guidance on what supplementary measures might be required, depending on the risk of the destination country? Yes, we will probably, we will be putting in a table with suggested supplementary measures. We've got a question about our methodology in relation to deciding if something's low or high risk. So you're right, they are subjective terms. We have a harms taxonomy which we can refer to within the ICO, which has been looked at. And then, you know, apart from that, it's about judgment, legal judgment, and again, indeed, your judgment on making that risk assessment. Sorry, I'm just trying to think. There's a question about the exceptions. If you're relying on one of the Article 49 exceptions, do you still need to conduct a transfer risk assessment? If you are making a restricted transfer and only relying on the say explicit consent for the whole of the data that you're transferring, then no, you don't need a transfer tool and you don't need a transfer risk assessment. The approach that I've outlined today does do a combination of the two, because having a transfer tool in place, such as the IDTA, provides a really good level of protection, so that it should be easier to be able to get over the hurdle to rely on one of the exceptions for data, because you only need to balance the risks that are outstanding, which you've just worked your way through in the transfer risk assessment. That sounds more complicated than it is in reality, and when you work through our tool, it should be much clearer how that works in practice. I'm sorry, I'm just checking through the questions, see if there's anything else that right, so shall I do one more question, because I think we've only got 1 more minute anyway. I'll just check if there's anything new that's come out. There's a few questions about who should be carrying out transfer risk assessments in relation to sub-processors and sub-processors. If it's the processor that's instigating the restricted transfer, let's say it's through a processor's sub-processor, only the processor is responsible for complying with Chapter 5 putting in place a transfer tool and carrying out the transfer risk assessment. When they're carrying out that transfer risk assessment, they also need to think about onward transfers. So that would be flows to sub-processors, sub-processors, and so on and so on. So they have two choices. They can either do a transfer risk assessment that covers all the data flows within that ecosystem, or they can pass down that obligation to their subcontractors or their processors through contract. And what the best solution really will depend on the transfer and how complicated it is, and really who is in the best place to conduct the risk assessments at each level. But what we're trying to do, remember, is to maintain those UK standards and maintain, you know, through the IDTA, those core data protection standards that are contained in them, including your transfer risk assessment, and make sure that flows with the data as it once it's left the protection of UK GDPR and left the UK. I think we're up to time now, so I think that's all the questions that we can cover. So just to remind, so thank you to everyone for coming along today. Thanks for all the questions. I felt it was a bit of a whistle-stop tour through all the questions because they were coming through thick and fast. Hopefully lots of the questions will be answered when you see the guidance, when you can see the tool and the TRA record. If you do have any feedback you want to give us, you know, do feel free to do so on those feedback forms. You know, you can put questions on there as well, and we'll try and answer them as part of our guidance. But remember, they are anonymous, so we won't be able to reply directly to you based on that feedback. But I think just thank you very much for attending and enjoy the rest of the conference.
Thank you.